Well, thank you very much for joining me for the second in this series of product liability webinars. This afternoon, I'm going to look at the development risks defense. What I plan to do over the next 25 minutes or so is to start by looking at why the defense is so important, look at its history, examine some of the main elements of the defense, and then consider in a bit more detail four tricky areas. And we'll see that this is not an area with an easy answer. My aim really this afternoon is simply to get you thinking about some of these points. But let's start by looking at the importance of the defence. Now, it's typically regarded as one of the most significant and controversial aspects of the Directive and the Consumer Protection Act. And in one way, that might seem surprising. There have in fact been remarkably few cases on the development risk defence in the UK, or indeed in Europe. The Court of Justice has looked at the defence only once, and even that was only indirectly. In England, the defence, when it's reached trial, has never succeeded. So why its importance? Well, it's important because it goes to the heart of the balance to be struck between consumers and producers when allocating risks in relation to products. Indeed, recent research on behalf of the European Commission concluded that defence plays an important role in keeping insurance premiums affordable and encouraging technical innovation, especially in innovative areas such as medical devices, pharmaceuticals, and increasingly in relation to complex smart products. But its practical impact is also much wider than the limited number of cases might suggest. So whilst the defence is rarely argued in court, it's often deployed by producers in correspondence and pleadings, and its use is not restricted to innovative medical or technological areas. Producers are sought to rely on it from everything relating to exploding glass bottles to baby sleeping bags, from condoms to food. In practice, its existence acts as a deterrent for certain claims being brought, as it makes them, especially in the areas such as medical devices, pharmaceuticals and smart products, more uncertain and expensive to run. On the other hand, the uncertain extent of the defence also means that producers often lack the confidence that a pleaded case on development risk will actually succeed at the end of the day. And the practical effect of this uncertainty and expense is probably to encourage compromise on both sides. In my view, it's one of the many reasons why relatively few product liability claims, especially in the pharmaceuticals and medical devices arena, actually go all the way to trial, others being the expense of bringing and defending such claims and the wider consequences for many producers of losing such claims. Now, if we go back to the origins of the product directive, the question of whether a defence should be included was a key point of contention when the directive was being negotiated by member states. The original draft, published in 1976, expressly stated in Article 1 that the producer shall be liable even if the article could not have been regarded as defective in the light of the scientific and technological development at the time when you put this article into circulation, i.e. the exact opposite of where we ended up. Now, this was regarded by many member states as going too far. There was a real concern that innovation would be stifled if producers were made liable for defects which could not have been known about at the time, and open them up to unforeseeable, unquantifiable liability. On the other hand, consumer organisations and academics were worried that a development risk defence would significantly water down the consumer protection and effectively reintroduce fault by the back door. And this was one of the many reasons why negotiations took so long, and the directive wasn't adopted until 1985, some 9 years later. In the end, it was agreed that the development risk defence would be optional for member states. Most member states, including the UK, chose to adopt it, but some, like Finland and Luxembourg, didn't. And others excluded development risk for certain elements or certain sectors of production, such as Spain excluded it for food, Germany in relation to pharmaceuticals. They had a specific regime for pharmaceutical products already. As said, the UK did adopt the development risk defence, but used quite different language when implementing it in the Consumer Protection Act. This led to an unsuccessful claim against the UK government by the Commission for failing to implement the directive properly. Now, I'm not going to get into that debate, which took up many pages of academic publications. The short point is the Commission lost, and it's now reasonably clear that although the wording differs, there is in fact no material difference in meaning. That's the effect of the Commission and UK decision and the subsequent English decisions, which all proceeded on the basis that there's no relevant difference in effect. I'll therefore focus on the directive's wording. Now, in the chat function, I've posted the actual wording if you wanted to look at it for Article 7E, but it says a producer shall be liable, a producer shall not be liable under the directive if he proves that the state of scientific and technical knowledge at the time when you put the product into circulation was not such as to enable the existence of a defect to be discovered. Now, before looking at some of the difficult questions that the defence raises, it's worth noting that certain points are clear. First, the burden of establishing the defence is on the producer. That on its face is a heavy one, given the need to prove a negative. Second, the state of scientific and technical knowledge generally is an objective question. In that regard, it doesn't matter that the producer did not know, or indeed that no one in the relevant industry knew, as long as the relevant knowledge existed. That's clear from the Commission and UK case. Equally, it's irrelevant that the producer exercised all reasonable care. In that sense, at least, it's wrong to say that the development risk defence introduced fault by the back door. What it did do was to restrict what would otherwise have been a more absolute form of liability. Third, the relevant knowledge does, however, have to be accessible. And in the Commission and UK case, the Advocate General distinguished between an American research paper published in an English language journal, which would be regarded as accessible, and something published in Chinese and Manchuria, which would not. And I'll return to that important question of what's meant by accessibility shortly. Fourth, in terms of timing, the question has to be judged when the product was put into circulation. That's an obvious point, but causes tactical issues for both claimants and defendants in group claims. The issue arises both from the question of defect and in relation to development risk defects, which both have to be judged at the time of circulation, the products put into circulation. The position, obviously, as to what safety can be expected and the state of scientific knowledge will obviously change over time. But group claims will often have products supplied over a wide period included within them. The strength of the claims in the group, and any defence, therefore, may differ significantly. And that will inevitably cause tactical difficulties for claimants and defendants in how to run and defend such claims. In particular, it may give rise to conflicts between different claimants as to how their interests are best served, depending on how the case is run. And that probably helps explain why, in practice, such distinctions between groups of claimants often aren't made, either by claimants or by defendants. But it is a point which is very much one that should be in one's mind when deciding how to put together a group of claims. Now, while some points are clear under the defence, others are much less so. And it's right to say that there's an overall tension as to whether the development risk defence should be construed very strictly on the basis that it's an exception to strict liability, making it obviously difficult to apply, or whether it needs to be applied more liberally so as to ensure that the protection of the development risk defence is not rendered meaningless. Now, I want to look at four tricky areas in this question where the balance should be struck. First, I want to look at what does the knowledge actually have to be about. Secondly, what is meant by knowledge being accessible? Thirdly, what does and doesn't count as scientific and technical knowledge? And can there still be liability if the development risk defence applies? Now, what does the knowledge have to be about? Well, in relation to that first point, what's knowledge have to be about? The answer is, of course, it has to be about the defect. But as we know, that is not necessarily an easy question. We've seen very different approaches to the question of defect in, for example, A, National Blood Authority, Mr. Justice Burton, and more recently, Mr. Justice Higginbottom and Mr. Justice Andrews in the Wilson, G and Depew cases. Put simply, the wider you characterize the question of defect, the more likely there will be relevant knowledge. In G, the metal and metal hits group litigation case, for example, if the defect had been characterized, as the claimant sought, as the propensity of metal on metal hits to cause an adverse biological reaction, this would clearly have precluded a developed risk defense because it had long been known in the literature that metal implants might cause a biological reaction. The issue was it was thought to be a very rare risk. If, on the other hand, the alleged defect had been characterized more narrowly by reference to, say, the clinical diagnosis of ARMD, adverse reaction to metal debris, or, as the judge preferred, on the basis that the revision rates, reoperation rates, were materially higher for metal on metal implants than for comparable implants, then there was an argument that the development risk defense might apply, as that knowledge, based particularly on experience in relation to revision rates, was only obtained later. Now, the defendants won on defect in G, so the pleaded case of development risk never had to be considered. But you can see how you characterize defect may well affect the application of the defense. Let me take another example. Say it is known from literature that ingredients of drug X can cause a fatal ischemic stroke. It turns out, unknown to anyone, that the drug can also cause a fatal hemorrhagic stroke. Is the defect to be characterized by reference to the mechanism of the injury? Is it an ischemic or hemorrhagic stroke? Or simply the outcome, death? If it's simply the ultimate outcome, then there'll be no defense as the risk of that, as the risk of that outcome was known. Another problem is whether the knowledge needs to relate only to the generic risk or to the ability to discover the defect in the specific product. Put another way, does development risk defense apply where the risk is known in general terms, but is unpredictable and undetectable in individual products? Now, in the UK, following the National Blood Authority case and Richardson and LRC, which is the fractured condom case, and in Germany, the answer appears to be that all that needs to be discoverable is the generic problem, i.e. that blood might be contaminated or that a condom might sometimes fracture, even if it's not possible to identify the defect in an individual case before it manifests itself. Essentially, once the risk is generally foreseeable, the defense does not apply on this analysis. But a very different conclusion has been reached in the Netherlands and Australia, whose product liability legislation is closely modelled on the Directive. And the distinction matters. So in the Australian case of Graham Barclay oysters, it was known that there was a general risk that oysters might be contaminated with hepatitis A. But there was no way of testing individual oysters before sale as to whether they were contaminated without destroying them. The court, applying almost the same development risk defence as that under the Directive, held that since it was not possible to detect the virus in individual oysters, the development risk defence would apply. On the basis of the National Blood Authority case in England, the opposite decision would probably have been reached, as the case was known, as the risk was known and no longer foreseeable or unforeseeable. But after the severe criticism of the National Blood Authority case in relation to the question of defect, it must be said that Ms. Justice Burton's conclusions on this point cannot be seen to be the last word on the matter. And certainly the discussion in the Richardson and LRC case, whilst assuming the point, contains no analysis. The point is not settled. I should say, in case you want to have something interesting to read, you should look at the Richardson and LRC case, which is a little gem. And it's the understated explanation given by the judge as to how this condom fractured and how it was then kept is very well put. Let me turn now to the question of what we mean by the knowledge being accessible. I mentioned earlier the distinction drawn by Advocate General in Commission in UK between something published in a Western journal and something published in an obscure Chinese journal. Now, that distinction, made some 23 years ago, now sounds rather dated, not least given how much cutting-edge research now comes out of China. But importantly, he did also refer to a reasonable test as to whether the information could properly be said to be accessible and in open circulation. Now, in the time of the internet, it doesn't really matter where things are originally published. Information can be accessed from anywhere. Even language isn't the barrier once was. Google Translate can provide an instant translation of almost all languages, even if the accuracy sometimes remains questionable. What this means is that it will, in reality, be much more difficult for producers to say the knowledge is not accessible, even if there is a reasonable test as to whether the information can be accessible. Now, in the National Blood Bank case, as Justice Burton suggested, only non-published material and internal research of other companies would be regarded as not accessible. Now, that may be too strict, given that the Advocate General talked about reasonableness of accessibility. So, for example, if relevant research is published in an apparently entirely unrelated field, which had not previously been seen as being linked, it may perhaps be said that the information is not reasonably accessible. But generally, it will be right to say that it'll be difficult for producers to argue information is inaccessible if it has been published somewhere and is available online. So turning to the critical question of what counts as scientific and technical knowledge, there are a number of problems that arise. Now, it appears from the Commissioner UK case that when we're talking about scientific and technical knowledge, we're talking about the most advanced scientific knowledge. So the fact that it is not in the mainstream is irrelevant. Once knowledge is out there, the risk can no longer be said to be unforeseeable. It is one that manufacturers can guard against by removing it from the market, adding warnings, repricing the product to take into account the risk, or insuring against the risk. The premise is that this most advanced knowledge, even if not in the mainstream, is in fact right. But what if the research is fundamentally flawed, even if it's accidentally identified a defect? There's a huge amount of scientific literature out there, much of it of dubious quality. As they say, give a monkey enough time and typewriters, and they'll come up with complete works of Shakespeare by hitting keys at random. What counts as knowledge? In my view, there must be a threshold for what's sufficiently cogent to amount to scientific and technical knowledge for these purposes. In part, this probably depends on where it's published. So peer-reviewed papers in reputable journals will clearly be enough as a source, but after that, where's the line? Are preprints sufficient? Preprints being articles which are put online before being peer-reviewed, blog comments by scientists, comments on articles. Very difficult to know where the line should be drawn. Even more difficult is whether the analysis needs to be right. If you've identified the risk or defect, but for the wrong reasons, does that count? What about just a scientist's hunch without any evidential basis? Risks are continually being identified in literature, and they often turn out to be founded on bad science or simply wrong. Again, the answer is probably fact and degree. Minor errors probably don't matter, but where the evidential or analytical premise is wrong or completely lacking, it's difficult to see how it should count as relevant knowledge. Otherwise, the hurdle for applying the defence risks becoming much too high. Also, how specific does the knowledge need to be? Does knowledge of a risk in relation to one drug provide knowledge in relation to a related ingredient which has not been subject to investigation? What if all the pieces of knowledge are there to reach a conclusion, but no one's put them together again? Science usually involves incremental steps, using existing techniques or data to go one step further in developing understanding. Again, the answer will probably need to be fact-sensitive. Where existing knowledge can readily be applied with only a little work to the product in question, there'll be sufficient knowledge. But where a material further step, especially where it's a creative step, is necessary in order to identify the defect, there will be insufficient knowledge. Related to this is the question of how certain that knowledge needs to be. Is it enough that the risk is identified as a mere possibility, or does a firm conclusion need to be reached? Here we do have some guidance from Australia, and as I said, they've got a very similar product liability regime. It's modelled on the Directive. In the case of Peterson and Merck, the court said the mere fact that research might trigger a suspicion of risk, and for example, the need for a warning in the IFU, was not the same as that amounting to sufficient knowledge for the development risk defence to be precluded. Firmer knowledge was required. That seems right. Knowledge must be more than mere suspicion of a possibility. Another issue is whether scientific and technical can include safety data based on what has happened once product is put into circulation. And this is a very important point. This may be crucial where the defect is identified by the rate of an adverse reaction. Let's say it's accepted that a certain type of cancer drug inherently has a 0.01% long-term risk of causing a stroke, i.e., such a rate does not cause the drug to be defective. In fact, the new drug has a 0.2% long-term risk of causing a stroke, but this is only identified years later when sufficient patient data has been analysed. Does this safety data itself count as scientific and technical knowledge, such that its absence allows a development risk defence to apply? What if the data could have been collected and analysed but wasn't? Does that count as available knowledge? Is constructive knowledge sufficient? Now, it's a live question in a number of cases I'm dealing with at the moment, so I won't say much more about it, but you can see that there are a whole range of questions to which there is really no easy answer. A balance that has to be struck between having an effective and usable defence, which protects producers from unknowable risks, and on the other hand, not going too far in undermining the principle of strict liability. Finally, I want to look at the point that even if the development risk defence applies, the producer may still be liable on other grounds. One of the oddities of the development risk defence is that the less new research you and the industry do before launching a product, the more likely you may be able to rely on the defence. The more new research you do, the more likely you are to identify potential defects. Similarly, it may be said that there's a perverse incentive to launch products before testing it properly, if that testing is going to reveal further potential safety risks. Now, that's a controversial issue, and it turns on the extent to which constructive knowledge is part of the development risk defence. But it's important to remember, in any event, that the Directive and the CPA are not the only games in town. In some cases, a claimant may have a straightforward claim for breach of contract for not providing a product of satisfactory quality. In such a case, the development risk defence simply doesn't apply. The question is merely whether the product is of satisfactory quality or not. Equally, where the existing state of scientific knowledge may not have allowed a defect to be detected, there may still be a claim in negligence if proper research, and perhaps just as importantly trials, had not been carried out before the product was put into circulation. So there may be a curious position where liability is in fact greater in negligence in such a situation than it would be following the application of the development risk defence, because effectively the risk of the product was such that it required attempts at new research. And even after the product has been put into circulation, there may be a claim in negligence for failure to provide updated warnings or carrying out an adequate recall if further information comes to light in relation to the risks posed by the product. So whilst the development risks defence is important, even where it applies, a producer may be liable on other grounds. That's all I wanted to say. I hope it gives you a flavour of some of the issues in relation to the development risk defence.